be raised up. Natural law approaches that. There are two ways to approach two logical methods of approaching the issue of gay marriage. Let's take, for example, the liberals, so-called liberal argument, which is essentially each person has a range of choice in partnership. This equality liberal argument is a very comfortable one. It's very natural for us. When you get to the abortion issue, the liberal argument's a very good one for the pro-life side. It's an individual, that person deserves life just like anyone else does. So the liberal argument is very strong. It's interesting how the abortion arguments, the gay marriage arguments, have to, on one side, go beyond the liberal argument. You have to go beyond the liberal arguments in the abortion case to argue for freedom of choice, ironically. And you have to go beyond the liberal arguments in the gay rights case to argue for traditional marriage. So how does natural law do that? Natural law says, what is the nature of sexuality? It looks at the nature of things. The nature of everything can be investigated to see what its purpose is, what its attributes are. And the natural law argument is the nature of sexuality is such that it joins together the two most disparate parts of the human species, which is not race, which is not age, which is not locality, which is sex. The nature of sexuality is that it brings together the two most disparate parts of the human physiology. And on top of that, our observation is through history, is that joining together has an immediate effect, which is beneficial for the enjoyment of natural law existence for everybody, which is the family. It has an immediate effect for the family. In fact, there's a stronger natural law argument for polygamy than there is for gay rights. Because with polygamy, you still have a family that is an emanation of the sexuality. With gay rights, you don't have a family that's an emanation of the sexuality. Now, there's the other element of sexuality, which is friendship, which is a deep friendship evidenced by sexual. And that you can have friendship evidenced in same-sex relationship. But you don't call that marriage. At least we use the word marriage to talk about the whole complex of the nature of sexuality in relation between those human persons who have the most disparate and which were given the physiognomy for them to be joined together in that way. That's the natural law argument, why marriage, family, should be limited to family.
Professor Tokaji, did you have something to add to that?
I must confess, I didn't find that argument very persuasive, and also that I had some difficulty in following it. I don't think there was anything unnatural about sexual relationships, romantic relationships between people of the same sex. And it's just a fundamental difference, I believe, between myself and Professor Forte. And I believe it is every bit as important to the pursuit of happiness for people who are attracted to others of the same sex, that they be able to marry someone of their choice, as it is for people who are heterosexual.
Other questions? Yes.
I have a question for Professor. On the one hand, you mentioned that most disputes on values and morals should be worked out in the political process. Later on, you mentioned that courts should ensure open process against the tyranny of majority. But isn't the nature of a political process that power is allocated, that certain groups have more power, and that the system, the framework by itself, has some sort of bias or leverage against another group? So how do you, on the one hand, maintain openness, and on the other hand, maintain an objective structure?
It's a wonderful question. So, and not an easy one. And look, I don't say that my political process theory leads to easy answers to difficult questions, but I think it gets us asking the right question. But let me try to flesh out an answer to your question with at least some examples. First, on the front end, we should make our political process as equal as possible. Now, the easy part is, well, part of what I focus on, right? The voting process, making sure that everyone is able to cast a vote and have his or her vote counted. Something on which I suspect we probably can all agree as a matter of principle, although we may differ as a matter of implementation. The more difficult part is ensuring some level of equality when it comes to political influence. And here I'm going to tell you what I think. This is a matter on which there are, of course, different views, but I believe that our political system as presently structured tends to advantage the wealthy. And the Supreme Court has contributed to this unequal influence by allowing unlimited campaign spending by corporations and wealthy individuals. This I take to be a serious problem, and I think the court, as a matter of constitutional law, should be striking from exactly the opposite direction that it has. On the front end, trying to make our political process as equal as possible. On the back end, what I think courts should be doing, again, I'm talking about what courts should be doing in interpreting the Constitution, is correcting for those inevitable inequalities that will exist in our political system. Even if we fix this campaign spending problem, I still think it is probably the case that people who are wealthy would enjoy greater influence than people who are poor. And so in engaging in judicial review of laws, I think courts should keep an eye out for the less advantaged among us and should show special solicitude for the rights of poor people.
Yes, in the back.
I just want to say, since this is wonderfully off topic, I'd love to say it as well. The political system also advantages those that are good looking and well spoken. And I mean, maybe the Supreme Court should, or Congress should say that Obama should speak half as much. Wouldn't that be a blessing? But in order to cut down on his advantages as rhetorically correct, but what the professor wants to do is equalize the advantages some people have earned, not those that they were born with. It seems to me everybody should be free to enter the political process with what they have.
In one sentence, there are some inequalities we can and should correct, others that we may not wish to, and the fact that we may not be able to achieve a perfect political system doesn't mean we shouldn't work towards a better one.
Yes, Professor Osterman.
Professor Forte, suppose a group gets together and they write a social contract and at the top of it says, we think natural law is a bunch of hooey, we reject it, we want a government of enumerated powers, we create a court to interpret. How would that work out? Would the judges have to interpret a contract among the people with enumerated powers, rejecting the concept of natural law? How would that work out?
Sounds good to me. Because what if they said in their preamble, we believe in natural law, and they made a certain kind of government? What if they said in the preamble, we don't believe in certain natural law, and made the same kind of government, right? Well, the government you described is one which objectively, if followed through on the rule of law, would allow for a free play of natural law attributes among the free people, whether or not they said so in the preamble. So, I mean, it comes out the same way.
It's something I can never waive. It's something that gets me regardless of whether I don't agree with it. I mean, if we get together and say we're not going to be bound by natural law, I'm still bound by natural law. If that's your answer, then natural law is just a pathology.
No. What I'm saying is that what you've done is you've created a positive law system in your hypothetical, which in fact, instead instantiate natural law values. And all I said was, it doesn't matter if you said so or not. If you, in fact, instantiated natural law values through the positive law, that's fine. That was your hypothetical. Now, if you want a hypothetical where you have Nazi Germany versus the United States, you have one based on a natural law conception, and you have one based on a pernicious conception of the human person, then we can talk about that. But what the hypothetical you gave me was a natural law society that says it's not a natural law society.
No, that's not the hypothetical is a group of people says we are not a natural law society. We do not want our judges to use natural law. We are setting up a system of enumerated powers. We want our judges to read this system and apply the system of enumerated powers with no arguments from natural law.
Oh, I see what you're getting at.
Yeah,
You're getting, see, the underlying premise of your hypothetical is that under a natural law system, the judges would be able to enforce natural law norms. Right?
No, that's not my hypothetical is I reject it.
No.
It's a contract among people to reject it. How would that work?
If you had a contract among people, which we did have, which says we're essentially developing a natural law society, that contract would include a limited judiciary. I thought I stated that in my proposition. So a natural law society limits what the judiciary can impose because it has certain objective goods that are for the people, which have been instantiated by the positive law, and no judge should then go outside the positive law. Every natural law theorist has always said the judge is bound by the positive law. If the positive law is wrong, that's a different problem. But the role of the judge is not to go outside the positive law. So a system that you just put forward does not look at all one whit differently from a natural law system in terms of the duty of the judges. The judge should not impose his personal preferences. He should impose what the positive law has told him to. It's the same thing. I'll just say it again, and I think the Professor and I agree on this. Judges should not impose their personal morality, even if they think it's based on natural law.
If you disagree, then your argument is irrelevant. I don't care. Because the judges, nobody needs to worry about it. Whether it exists or doesn't exist, doesn't matter. Judges do the same thing.
But you seem to be thinking that all law comes from the judges.
No.
You seem to have a judge-centered notion of law. Our whole society creates the matrix of law. I guess we better argue about this.
Professor Tokaji,
Well, I was just going to pose a question to Professor Forte, which I think is a follow-up to Professor Osterley's question, if I might. So your idea is that legislators, when they make law, should be informed by the conception of natural law, when they make positive law.
Sure.
Yes.
Are legislators informed? Are people informed? I think if you took a census of the American population, they wouldn't know what objective goods were. They may have a sense, they may have a feeling, but I think that sense or feeling is different from person to person. So who is the authority that dictates what the objective goods are? Because I think everyone would agree that they're different for everyone. And I don't think people sit down and examine life and take the time to determine what the root of an objective good is. So who's the authority?
Right. The people are in their corporate capacity. I think that's the genius of the American legal system, because in the corporate capacity, what you have are a number of millions of people who are, in fact, whether they have rationally constructed it as a natural law system, pursuing certain objective human goods. They're pursuing friendship. They are, in fact, doing it. They're pursuing friendship. They're pursuing knowledge. They're pursuing relationships. They're pursuing play. Then when you form your political society or a law, whether it's a law against discrimination or a law to help the poor, what you do is you consult the people through their representatives. And in effect, you're asking, does this further, as the professor would suggest it would, and I would agree in many instances, does this further the capacity for people to pursue those goods? That's why a democratic system is about the best, because what it does is collect all these experiences, and in effect, we apply it practically to certain kinds of social performance.
So So in 20 years, when they have another